Welcome to the webinar. Thank you for joining us again. We are very excited to have a follow-up as to all the things that we talked about last week concerning COVID-19 and landlords. We had Brad Barth and Stephen Williams here on the call last week. We have them here again to give us an update as to what's happened in the last week. So as you know, every day is a little bit different with this situation. And so the best thing that we can do is to stay as updated as possible. And so that's why we're turning to the experts to find out what's new and then also to answer your questions. So I opened up this session to just receive as many questions as possible from you, and you really took advantage of it because we received 50, 60 questions that were super detailed. So I've condensed some of them for the purpose of this webinar to just make it short. But I will be sending the full question to Steve and Brad if they need to follow up with you specifically. But a lot of you had some overlap, so we're going to kind of condense it. But what I'd like to start with first is Brad giving us an update, and then Steve, as you know, I'll repeat it again, Brad Barth is the partner with the firm Barth Calderon, nationally recognized expert in asset protection, estate planning, and business planning. And then Steve, who's the founding partner of Fried & Williams, an expert attorney representing landlords. Both are frequent lecturers, and we've had them on now several times. Thank you again for coming on. So I'll give it to you, Brad, to get started.
Great, thank you very much. And I think you said it perfectly. There's every day is something new, and we gave this talk. I think it was 1 week ago today. And not only have I had some one-to-one phone calls with some of the attendees of that webinar, but just through the normal course of my practice, my normal clients have come back. One of the things that I was worried about, like all business owners, we're all worried about, well, what's going to happen with the clients and what's going to happen with the revenue. And there's been no white space on my calendar whatsoever. It's just been, they're coming in for, I think, all the reasons why everybody is online. They want to learn more and more about what to do, what's the outcome, what are some of the resolutions that they may have. But I think a lot of the other things, as I talked about last week, a lot of the calls are just as important regarding their overall estate plan. And I think it's important that perhaps maybe on a different webinar, maybe we have a different, we dedicate some more time to just doing estate planning in general, because this is a topic that's coming up more and more and more. I did address specifically the powers of attorney for property management and healthcare during last week, and why that's important for the immediate concern. But unfortunately, I just heard President Trump on the news just yesterday. They're talking some pretty scary numbers, and they're also talking a longer duration than I think some people are anticipating. So I think making sure everyone's estate planning is in order is probably a very important and timely thing to discuss as well. And just like we're doing here with education, that's just another form of education that we can provide to our members, especially our high net worth individuals and our property owners. So with that behind me, I want to go ahead and address what's new. So here again, and I think I may have mentioned this last week, there hasn't been a day that's gone by or an hour or so within emails where there hasn't been someone asking me about, what do I do about the tenants not paying rent? What do I do about my own cash flow issues? What about my own lenders? And I have received some follow-up from clients of mine who said they have contacted their mortgage company and they have put those on hold. And so there is some respite for at least the immediate needs for cash flow. I've been speaking with my senior partner as well, just as a business owner myself. What are some of the things that we're doing with our employees, so with our obligations, with our rent? And now that the new Trump law is in place, how do we apply for the small business loan? And what are our anticipated dates of receiving this, and what are some of its limitations? So thankfully, there's just a whole bunch of information that's available to the small business owner right now as to what President Trump has done to help small businesses. So I think it'd be a good piece of advice, while all of us have a little more time in our hands than normal, to spend a couple of minutes and doing a little bit of research as to how the government is taking some affirmative steps to helping the small business owner meet their demands. The concerns that are coming up, besides some of the estate planning issues, dealt specifically with with rent issues. And I think, Steve, you addressed it perfectly last week where you talked about some of the nuisance issues, the common area liability issues. I think that was addressed beautifully, as far as that, even though we may have some challenges as far as controls, nothing still prevents a landlord from taking affirmative actions if there's tenants that are not paying rent and or have nuisance issues within the common areas. So the challenge we have, and I think we also addressed this last week, is that, well, the courts the courts are shut down. Right? So our enforcement mechanism has been slowed down. And I was just speaking with a client yesterday who's going through some litigation, and what was set for a court hearing basically a couple of months ago is now going to be pushed back, I'm sure, easily 6-7 months from now, which gives them, the parties, more time, and hopefully cooler heads will prevail. Kind of gives them an opportunity to reach hopefully a settlement during this time, while they're waiting for the court to kind of weigh in on things. But I think for our landlords, they may be in a difficult position because eviction processes typically require some type of court intervention, and then the enforcement of such also requires either the sheriff's department or some other type of intervention, which may be a limited resource right now. So these are issues that all of our clients are dealing with, and I think that the litigation tidal wave. I wrote an email this morning to one of our vendors, and I said, listen, I think the litigation tidal wave is still going to be coming. I think it's a tidal wave, not only from business owners to vendors, and vendors to business owners, and employees to employers, and employers to employees. I think it's going to be I think the backlash, or I would say the consequence of this from a litigation point of view, is going to be unprecedented. And so I think from an asset protection perspective, regardless of what it is that you do, if you're involved in landlord tenant, or you're a property owner, or you have a side hustle, you have an Amazon business, or you have I think any type of business, we're going to be experiencing an unprecedented amount of litigation that's going to fall out from this. So I think if asset protection was ever on anybody's mind, now is the time to take action. I think one of the most difficult challenges I think that we deal with is the timeline with our clients. There are times when you can do things from an asset protection perspective, and there's times that you can't do things. There's something that's called the Uniform Fraudulent Transfer Act. In some states, it's called the Uniform Fraudulent Conveyance Act. In states like here in California, it's called avoidable transaction. So there are things that can be done in advance. It's kind of similar to buying an insurance policy. You have to have the insurance policy in place before the need arises for the insurance. And I always give an example of a fire, and it's just God forbid you have a fire at your house. You can't then, after witnessing the fire, call up your insurance agent and say, I need to buy fire insurance, right? It's too late at that point in time. The event has already occurred. So asset protection, or any kind of asset transfer, kind of falls into that category, that you have to have the entities and transfers done. We say we like them old and cold. The entities have to be in place. The transfers need to be done in place. The assets have to be settled in place before the need arises. You want them old and cold, because when the transaction arises, if you've done the transfer for the specific purpose of trying to hinder, delay, or somehow defeat a creditor's claim, then those fraudulent transfer clauses, those voidable transactions, all come in. And what does that mean in plain English? It's quite simple. That if you have a car accident on Monday, you can't transfer your assets on Wednesday with the intent of voiding the Monday accident claimant, right? You see that the event occurred on Monday, the transfer took place on Wednesday. They can reverse it. They can legally set it aside. Whereas if you reverse the transaction, now the transfer took place on Monday, and then the accident happened on Wednesday. So transfer on Monday, accident on Wednesday. Now, the Wednesday plaintiff can't come back and say, the only reason why Brad made a transfer on Monday was to hinder my collection efforts. Well, That's legally impossible because that person on Wednesday didn't even exist in my universe at the time I made the transfer on Monday. It goes to what my intent was. And so we always want to have these transfers in place before the need arises. And so as we see now on the horizon, okay, if there's ever, as we say, we were all saving for a rainy day, and guess what? It's raining. Right? It's raining. Storm clouds are on the horizon and it's raining. And so now is the time, if you're going to take any steps towards protecting your assets, whether it's real estate, it's stocks, it's bonds, it's cash, it's making gifting to your children, it's updating and reorganizing your estate planning. Now is the time to move. Because if we have, God forbid, litigation on the back end, we want to make sure that those transfers are old and cold so they won't be subject to those fraudulent transfers and voidable transactions. So I think from an update, I just kind of wanted to reiterate some of the importance on timeline, some of the calls that I've received and emails that I've received. I think it's almost reiterating what we spoke about last week. And with that, I'll let Steve have some opening comments as well. Thank you.
Great, thanks, Brad. No, I think that's important that you mentioned to be proactive rather than reactive when it comes to asset protection.
Yes.
And I mentioned in my last presentation the importance of the insurance. And again, for the same reason, be proactive now, because that insurance is not going to help you once you're sued. You can't then get insurance and then backdate it. You got to have it before. So be proactive.
Right.
And another thing that you mentioned, and it may bear a little more from you, but the importance of that power of attorney. And the reason I mention this is because I just had a client who unfortunately has a building in San Francisco, and I found that he contracted the COVID-19 and ended up in a medically induced coma. And, when he was, able to communicate, he was concerned, well, what do I do with my tenants? How do I handle that property? But then also medical issues or medical decisions could come about as well. Fortunately, he's not fully recovered, but he is home. So he's on the road to recovery. So that's very fortunate. But there was that period of time where, what can I do? Who can help? Who can, manage this property for me while I'm recovering in the hospital?
Right.
And I think, before I go on, maybe you just want to follow up on that a little bit as well, Brad.
Sure. Thank you, Steve. Yeah, and I did address this last week, and I think it's, like I said, it's definitely worth reiterating because it goes right to the heart of one of the concepts I mentioned last week, and that was who manages your stuff if you yourself are unable to, and not only having the power to do it, making sure you have the right person doing it. You remember we talked about the use of that limited power of attorney for business or property management as opposed to the overall general power of attorney. So I'll just, again, use myself as an example. So if I had a general power of attorney for property management with my wife as my agent, which she is, she takes care of the household and the bills and litigation. But my wife may not be the best person, Steve, to try to evict a tenant. Maybe she doesn't know the first thing about that, but I have a business partner. His name is Steve, and Steve is my business. He's the one that understands the clients. He's the one that understands the process of being able to evict someone. So although my wife may be the perfect agent for all of my personal affairs, but when it comes to my business or a specific need, maybe Steve, my partner, is the best agent for a limited power of attorney. But what you're addressing is exactly what these documents are intended to do. And I told you last week, I'll tell you again, the powers of attorney are always the Rodney Dangerfields of estate plans. They never get any respect. And now it's taken this little virus to be able to shine a light on the one area that nobody really pays attention to. They're always worried about the post-mortem stuff. They're always worried about probate avoidance. They're always worried about who gets my stuff when I pass away. But now you're seeing how important the documents are because these speak for us. If we're unable to make medical, who makes it? If we're unable to manage our property, who does it? And you need to speak now while you can, because there could come a point in time, unexpectedly, completely blindsided, where you can't. And now you're stuck with what you have on the documentation. So thank you, Steve, for highlighting it. It's definitely worth reiterating. Thank you.
And when you when you say that it gets no respect, you're supposed to do the whole Rodney
Oh
Dangerfield.
yeah, yeah. I don't have a tie on though. I got it.
The younger generation may not be familiar with that particular routine, but
I know we're dating ourselves.
in any event, back to the landlord-tenant issues, and again, like you, Brad, I'm seeing, just on a daily basis. Like for instance, in San Francisco, there was an initial order from the mayor that dealt with the emergency and then dealt with evictions and potential moratorium on certain types of non-payment of rent evictions. There have now been 7 supplements to that order. And that's not uncommon throughout the state and probably throughout the country as well, where there, again, 7 supplements over about a 3-week period. So they're cranking these things out, every other day practically. So again, it's important to be dialed in and tuned into what is specific in your jurisdiction. But I will say this now, and I'm sure all of you or most of you are aware of the Relief Act, the CARES Relief Act that was passed. I think it was finalized after our last meeting. And some important stuff came out of that. And I think Brad touched upon it as well, that there could be some relief for small businesses like property owners and individuals as well that you could avail yourself of through that package. But there's another component that's got me a little, I don't want to say concerned, but definitely affects my area of law. And believe it or not, there appears to be, and I'm still trying to flesh it out, it's still very new, a sort of a landlord-tenant component and a moratorium on non-payment of rent evictions at the federal level. So, and Brad, you and I talked for a moment before we got on this webinar about, local jurisdictions certainly have rent and eviction controls in certain cities throughout the country, especially here in California. Well, even the state of California has a statewide rent control and eviction control. There are other states that have that as well, like Oregon, for instance. I believe Oregon has one. And I believe Nevada is contemplating one. And I'm sure there's other states that either have it or are contemplating it. But those eviction controls are in place. And then, so you've got your local rent and eviction control, your potential statewide rent and eviction control. Then you've got your local emergency orders that impact the ability to avail yourself of the right to potentially get rent, for instance. Then you've got the state level doing the same thing, and now possibly the federal level. So it's important to be, dialed in. And at this point, like I explained, I had a great conversation with an AAOA member following our last presentation, just about a strategy and really just trying to work with the tenant during these emergency times to one, try and get your rent, but if you can't, get as much as you can. And if you can be sympathetic and just be willing to work with the tenant, because what I'm seeing is a lot of these orders are putting moratoriums or restrictions, but also encouraging, there's actually language in these orders encouraging the landlord and the tenant to try and work out a repayment plan. Like for instance, the repayment plans I'm seeing are generally about a 6-month repayment plan in some of the orders.
Right.
But even that saying, look, this is not, hard and fast that it has to be limited to 6. You can extend it beyond that. And so they're encouraging good faith meet and confers with your tenant to try and resolve any inability to pay rent and to try and get the tenant back on track and possibly, hopefully even get you your rent, even though it may be delayed a period of time. And I'm also hearing some potential pushes in some areas, including San Francisco. It seems like San Francisco is the forefront in a lot of this stuff, as well as maybe even at the state level for the government to basically forgive rent altogether. So not even have any sort of obligation to pay in the future. Fortunately, I have not yet seen anything like that pass, but there are some rumblings, some advocates who are pushing to do just that. So again, it's very fluid. Every day and every other day, there's some, local, state, or federal proclamation or order. So it's just important to stay in tune with that. And in the meantime, at this point, just try to get what you can and work with your tenants to accomplish getting what you can at some point in the future if you just can't do it now. So that was pretty much all I wanted to summarize. So, and Brad, unless you have anything further, I'm happy to open it up to questions now, Alexandra.
I just think that it's important, since we have a very large audience, and this is one that came up from our last conversation. And we did speak about this before coming online. If you would just maybe spend a moment or two talking about that AB 1482 proposition that just that came through as of January 1st, 2020 for our California audience.
Yeah, so specifically for California, and again, other states may have very similar legislation, but in California, effective January 1st, statewide rent and eviction control went into place. There are a few exceptions for like brand new construction and also single family homes that aren't owned in a certain type of entity, basically a corporation or a REIT. All residential property now in California is subject to pretty strict and stringent rent controls, limiting the amount of rent you can increase each year, and eviction control, requiring you to have just cause in order to displace a tenant. A lot of local jurisdictions like San Francisco, Berkeley, Oakland, Los Angeles have had very strict local rent and eviction controls in place for many years. And the state law does not supersede those local laws. So for those individuals or owners in those areas, it's pretty much business as usual, and you're stuck complying with your local laws. But for areas outside of those those local jurisdictions where we've had and been used to rent and eviction controls for many years, well, it's very eye-opening, because now at the state level, every unit that was not previously subject to rent and eviction control now very well could be, depending on the size or number of units and ownership. So again, and then so this is, these laws are, again, in addition to whatever emergency orders are in place. So for instance, under the state law, eviction and rent control, you can evict for non-payment of rent, as you can in every local jurisdiction as well. But this emergency law would now supersede that, saying, well, yeah, while you can't right now. This moratorium is in place. You're going to have to be on hold until the emergency orders lifted and until these moratoriums are ended as well.
You mentioned single family homes, but what about duplexes, threeplexes, fourplexes, condos, apartment buildings? I'm seeing here that also duplexes were exempt, that were also owner occupied. Does that extend also to multiplexes in general, or is it limited to just duplexes?
Yeah, it's limited to, I believe it's triplexes or less. But if it has to be owner occupied. So
right.
if it's owner occupied, then it's either duplex or triplex. I'm not sure right offhand, but at a minimum, it's a duplex that's owner occupied. Then right. You do get some relief from the statewide controls. But anything above that, it doesn't matter if it's occupied or not by an owner. The other units will be subject to the rent and eviction controls.
Yep, is referred to as AB 1482 for our California audience.
Yes, definitely something that we might be doing a follow-up on for our California audience. I think it's more detailed than that and extremely important to be aware of now more than ever.
Yep.
So, if it's okay with you guys, I can start with some questions, although it sounds like you answered a lot of the concerns already that I've been getting from people. The first category is really mortgage or other sort of assistance for landlords. So you mentioned the CARE Act, mentioned reaching out to your mortgage provider, finding out a solution with them. What do you think is probably in general the best first course of action?
So Brad, I'll let you answer this or start with it.
Yeah, sure. So we kind of addressed the idea, which Steve and I both I think said last week, and worth repeating is get on the phone and try to speak with your mortgage company. As I mentioned earlier, I had an email this morning about a client of mine who's looking to apply under the CARE Act for some employment issues, and one of the things that he had mentioned, well, we already spoke to our mortgage company and we're getting a temporary stay on payments. So he took the affirmative action to speak with his lender. I myself have done that. I know that I've recommended a lot of my clients to do so. It may be difficult to get a hold of them on the phone, but maybe through email services, through your bank's website. Maybe there's an FAQ section on what to do under these circumstances. So I think, to your point, what was the first action? I think was simply is to contact them. I don't think the answer is just to throw your hands up and say, I'm not going to pay them. I think trying to work out some type of resolution or temporary stay on payments, because as Steve had mentioned, there's going to be some way of kind of repaying or recapturing the unpaid mortgage over the next 6 months or so. So with that, I'll turn it back over to you, Steve.
Yeah, at least in California, I know our governor here, Governor Newsom, has negotiated with some of the lenders, some of the major lenders, that there will be a deferment on mortgage payments. And, for those who are in need, I'm not sure the length of that, but I want to say it's at least 90 days or more. And then also there's various SBA loans. There's the disaster relief loan, as well as if you are, a property management company or a property owner who maybe has a few employees, that you may qualify for some form of a loan to help you during this time. At least to make payroll or to satisfy any expense obligations, like potentially mortgages. So there are things out there, but as Brad mentioned, remember, this just passed, and everyone is rushing to these websites to fill out the applications, and so there may be some delay. There may be some difficulty reaching someone to answer questions, and I am aware that at least the payroll protection funding application is not yet available. I heard that it will be available within the next few weeks, so you can't even apply for that yet. Again, this is all so new, but just again, stay tuned and follow up with any of this. All this money that's being flooded into fund these types of loans for people in need.
Great. Yeah, those were questions I got from William and Joy from California. So I'm glad you addressed California as well. Have you heard of anything in regards to pausing or deferring utility bills?
Well, I think also I have again, I can't pinpoint an exact spot, but I think there's also a temporary stay on those payments as well. I haven't received anything particularly in my inbox from Southern California Edison, or the gas company, but I've been speaking with some of my professional colleagues, and I think they're all of the opinion that there's going to be some stay on that as well. I think that also applies to the DMV too, as far as if you have to make payments on DMV, things that are coming due, license renewals or registrations. I think they're also giving some type of a temporary stay on that as well. But just to echo what Steve said, it's all new. A lot of the information is going to be going to the company's website themselves. I found the FAQ sections have been pretty helpful, trying to find out. They're all kind of on their homepage or having a banner saying what's with COVID-19 and how is it affecting our services that we're providing to you. So definitely worth looking into that.
And I just to follow up too, and again, this is in my area here, that there are some restrictions on them shutting off service to you. I don't believe, at least the main gas and electric type providers are not going to cut off service for non-payment at this point. Now, in terms of working out payments, I don't know what the protocols are in place for that, but obviously they're going to have to defer it. But in terms of any relief, I'm not sure regarding the payments, but I'm pretty sure there's some protections in place that are going to prevent them from shutting off service altogether
Mhm.
to you
Yeah.
for now.
Great. Yeah, that question was from Christopher from Los Angeles. So the other question as well in assistance is whether or not, and this is a California question again from Christopher, whether the governor of California will forego the collection of property taxes during the 2019-2020. It's supposed to be due April 10th. Do you guys know of any extension or the possibility of one?
Yeah, I'll let Steve answer that one.
Yeah, I'm not aware of any extension on that, but I would assume it is coming. I have not looked into that particular issue. But what is in place is the governor's emergency order, not the shelter-in-place order, but the actual emergency order in California, at least, is extended through September 4th. And there are a lot of restrictions that come about as a result of that, as well as deferments. And I would not be surprised if it has not already been pushed back, if it will be pushed back. As you know, the federal filing of taxes date has now been pushed back. I'm not sure how far. I think it's in July or something. But I can't imagine that they're going to be enforcing, the property tax payments due on that exact date. But I'm just not sure.
Yeah, I mean, it seems like in general there's an understanding that things are going to be delayed, and I think it's a matter of just finding out when it's going to become due. Okay, so going to the next category about asset protection, somebody named Ayub from Michigan asking, should I refinance my rentals so that there's no equity in case of a lawsuit? Why do I need an umbrella LLC? Also from
Okay,
Ayub.
great. So what they're referring to on the first part of the question is called equity stripping. And it's a very common technique that we use because when somebody sues you personally and they're coming after the assets, one of the assets may be the actual real estate. And real estate, unlike cash, really can't be moved around so much. It's very difficult to move a piece of real estate that's kind of fixed to the ground. So you have this immovable asset. And typically when someone goes after a piece of property, they typically don't want the actual dirt itself. What they want is the value that that dirt represents. So the greater the value, the greater the equity corridor in there, then the more attractive that asset looks to a creditor. So if you take, for example, a piece of property, again, we'll use simple numbers, $1 million piece of property that has zero debt. It's $1 million. So if somebody were to go and foreclose on that $1 million asset, okay, you're not going to get $1 million because it's probably going to be a judicial foreclosure sale, so a little bit of a fire sale. You're going to have cost of sale, so maybe you net $900,000, let's just say. Now, that's $900,000 of cash. They don't want the dirt, they want the cash. So that's a very attractive asset, a $1 million asset that someone can go after. Okay, now, for example, you go ahead and do what the attendee's question is what if I put a loan against it? What if I strip the equity out? So I have a first or I have a second on there. Now my equity corridor went from $1 million, maybe now down to 200,000. But remember, you got fire sale and you got cost of sale. So now all of a sudden, there's actually no equity in. As a matter of fact, the property may be upside down as a result of the encumbrances. So now you have the same exact $1 million building. How attractive is that to the creditor? In one example, it's $1 million, very attractive. Now that you're using debt as an asset protection tool by stripping out the equity, now the exact same building is unattractive because they're going after the asset, but they're going to get nothing for their efforts on the back end. The second part of the question, however, is very important. If you simply strip out the equity, now you got cash. So in my example, you have $1 million property, and let's say you get a 95% loan. As crazy that may be, 95%. You pull out $950,000 in cash. Okay, now the property is completely encumbered and has no value, very unattractive. But you're sitting on a pot of $950,000. So the next question is, what do you do with that? So if you did that, you've actually done your creditor a favor because you pre-liquidated the property for them. So in one way, although it's not a great place to put a lot of equity, at least it requires action on sale and cost of sale to get that equity if they were to foreclose on the property, as opposed to you sucking out the equity and stick it in your bank account. So the question is, if you do that, so the answer is a two-pronged approach. You do an equity stripping program, and then you take the net proceeds of that equity stripping, and now you have to protect that. So the cash is protected and the property now is fully encumbered. Okay, so that's actually the answer to the first part of the question. The second part of the question has to do with an umbrella LLC. Now, we use those quite a lot. And many times if we have clients that come to us, so I practice here in California, so I have a lot of clients that have California LLCs. If they've done their job correctly, they've diversified each of their properties in separate LLCs. So they come to me with 10 LLCs. They say, Brad, I have 10 LLCs. And I say, great. You know, California is not the best jurisdiction for holding real estate, you know, from an asset, not for limited liability, but from an asset protection point of view. Remember, there's two sides of this coin. So from an asset protection point of view, California is not that great. So we look to other preferred jurisdictions, and Delaware, Nevada, Wyoming. There are other states that have more favorable law. Then my client says to me, so you mean to tell me I have to convert 10 entities now? And the answer is no. The answer is you can create one umbrella protective LLC in a protective jurisdiction, and then you can put each of those 10 California LLCs underneath it. So that is a very common use of an umbrella type of protective LLC, where it's being used to not have to modify 10 underlying entities. You just take a protective umbrella entity on top, which prevents the creditor from coming in and getting down to the assets down below. So I think that kind of addresses the equity stripping and the umbrella LLC usage.
Yeah, great response, especially timely now. So the next category is really just move-in. So I received a few questions about, okay, so we have a vacancy during this time. What are some of the changes? So can you ask a tenant where they've been? I think last week we talked about, can you ask them to provide some sort of proof of their health or whatever? And you said no, that's probably not a good idea. But at least can you ask them where they've been? Can you, if they want to change their mind, let's say they signed the lease, they were about to move in, they change their mind, can you do that? Are you supposed to let them now that their situation is in place? Do you know of any legislation where you can let a tenant basically change their mind at this point?
Yep, I think we lost it.
Oh, sound.
To answer the first part, I would refrain from asking any specific information about where they've been. For instance, let's say you ask someone, well, within the last, 14 days, have you traveled outside the United States? We know that wouldn't be the case, but just as an example, say, yeah, I've been to, China or Mexico or anywhere for that matter. And then you elect not to rent to them. That could be construed as possibly discriminatory, based on where they have been. There could be some sort of protected sort of class that is being discriminated against just by virtue of them being in a certain part of the world. So I would refrain from asking anything. Just do your general standard screening, and of course exercise safe distancing and protocols. I have clients who aren't showing places right now, real estate agents who aren't listing places right now because of the protocols that are in place. So keeping that in mind, how to exercise safe distancing and and protocols to to prevent the spread of coronavirus. Other than that, use your general screening and background. So, and then what was the second part of that? There was a.
So if the tenant signed the lease, maybe even paid the security deposit, they changed their mind and decided not to because of this.
Yeah.
Do you have to give them back their security deposit? Can you cancel the lease? Like, is that something you're
Yeah.
supposed to do now?
Yes, we talked a little bit about that earlier and about lease violations or breaches. Um, in general, probably, you have to look at the particular lease agreement, but the general concept of, an act of God being the reason for breaking the lease, um, and treating, the outbreak as an act of God, that's probably, again, a case by case basis, but probably not sufficient to violate the lease. That being said, I would treat every case individually, and owners do have a duty when a lease is breached, any contract for that matter. This is in California, and this I assume many of the states as well, that the owner has a duty to mitigate their damages, to mitigate the liability. So they would then have to try, using best efforts to get a replacement tenant and minimize the potential liability. But sort of like with the rent payment issue, I would probably recommend in this circumstance that the landlord try to work with the tenant. Maybe there's some workaround that the tenant can still move in. Maybe it's at a later date, or alternatively, some agreeable way to let the tenant out of the lease. But the security deposit is really held, that is exactly what it is. It's a deposit to secure performance of the lease. If the tenant doesn't perform, then the security deposit can be used to offset any damages that the landlord incurs as a result of non-performance, subject to any obligation to mitigate those damages. So technically, the landlord could potentially use that security deposit to offset damages. But again, in this circumstance, I would strongly recommend and encourage the landlord to try to work with the tenant.
Okay, and then going on to safety and communication during the tenancy. So if one of the tenants in the building gets coronavirus, is there an obligation to tell all of the other tenants in that building?
Yeah, I have seen this, and I do believe that there is and it's debatable whether it's actually required, but I think it's good practice to notify the other tenants. Now, you don't want to single out the tenant, okay? So if you're aware that tenant in Unit A is the one with the coronavirus, you don't want to tell everyone tenant in Unit A has coronavirus, just like you wouldn't share any medical or disability information about any particular tenant in the building. But I do think it's a wise practice to let the tenants in the building know that someone has been diagnosed with coronavirus in the building, and that it's important that everyone shelter in place as is required and take all the reasonable and required protocols to prevent the spread of coronavirus.
Yeah, Steve, this is one of the questions that I was talking with my senior partner about the other day, and getting back to the common area issues. So now the landlord becomes aware that the person in Unit A has a medical issue or this coronavirus, and one of the difficulties with an invisible boogeyman is you never quite know who to blame or who's ultimately responsible for this. So do you see, and I mean, I see it, but I'm just asking in your opinion, do you see the same level of tidal wave of liability being brought on to landlords? Because any tenant can come up with, I guess, a reasonable argument that I got it because you didn't take necessary actions to protect me from person in Unit A.
Sure, and anyone can sue anyone for just about anything. We talked about that last time.
Right.
And additional steps, in addition to giving that notification out to everyone, is the landlord then also should probably take additional precautions, maybe cleaning,
Right.
additional cleaning with disinfectants of common areas on a daily, or maybe several times, or at least twice daily, to ensure that the area is being properly sanitized, in addition to giving that notification. But absolutely, and like I said last time, is that if someone gets sick and is hospitalized and maybe seriously injured or worse, and they can point the fingers at the owner that of a property, then they probably will, because that's where the pockets are.
That's right. Yeah, that's right.
Yeah, and I think that really knocked out a bunch of questions. So, people asking, how often should I be cleaning? And during move out, how much should I be cleaning or waiting for a new tenant to come in? If
Right.
there's some sort of liability there. And the answer really, it seems like, is just do your best to
Yeah.
reduce as much liability as possible. But at the end of the day, you can still be sued.
Right.
There's
So
not a lot you could do after
right,
that.
working a lot with defense counsel, and we call this, you want to paper the file, right? You want to make sure that you have enough evidence of the reasonable steps that you've taken to the best of your knowledge, to mitigate the risks. And so, to Steve's point, okay, so you go out there and you disinfect it two times a day. Okay, I would definitely document that. I would document what times you do it. What protocols did you use? Was it one Clorox wipe per doorknob, or did you use the same one for every doorknob on the floor? What did you do? Because ultimately, remember, plaintiffs counsel, their job is to try to tear things apart and pick and poke and do Monday morning quarterbacking for everything. So I think the best thing that anyone can do is to be, as they say, drive defensively. And same thing here, be as very defense minded as possible and build that file. What did you do? How often did you do it? What tools did you use? What type of protocol did you use? Did you go on to the CDC and follow their recommended cleaning list if one's available? But I think it's important that they have some reasonable documented explanation, because when you're on the receiving end of a deposition, sometimes absent having something to refer to, it's pretty easy to kind of poke holes and make innocent people and people who did do their best efforts look careless, right? And we don't want to have our clients in that position.
I think that's a good point. Go ahead.
I was gonna say, I think that's a good advice, and I always tell clients is, paper your file. When someone comes to me, I'm looking, all right, well, let's look to the future. When the tenant's claim comes, what do we have to document what you did? And not just papering the file, but sending, written communications to the tenants. So like I mentioned earlier, notifying the other tenants in the building. I wouldn't do that with a phone call, although you may do it with a phone call, but follow it up with something in writing, something that documents what you're doing or have done. Again, that's not only papering your file, but that's creating a trail to let you establish and that the tenant was aware of what you were doing and what has transpired. Just as an example, just yesterday, I had a client who had a tenant who's just a complainer, and had complained about mold. And they had their own mold testing. Our client then went and got their mold expert to come out and test the place, gave it a clean bill of health. Still, nothing was going to satisfy this tenant. This tenant moved out and sent a very lengthy email saying, I moved out because of the mold, and you didn't address it. Where our client obviously did, and they papered the file, just was not enough. So the question was, well, now do I go in, now that she's out, do I go in and do another mold test? While in general, under general circumstances, no, it wouldn't be necessary. You just had one done a month ago. The place is clean. The eye test shows it's in the same condition. There's nothing wrong. But out of an abundance of caution, because of the circumstances in that situation, a few $100s to get another test done to hopefully, eliminate or at least establish that there is no mold there, again, would help paper the file and put you in a better position. Same here. If you want to get, a professional cleaning company to go out there and sanitize the place after someone has moved, during these times, again, that's an additional protocol that you could do to show and paper your file that you're going above and beyond what might otherwise be required.
Okay, good point. And I think the same probably goes for the next couple questions, which is just anything that's not emergency maintenance, right? Maybe not putting those off as much as possible. I think that's also another good suggestion and kind of answers the next couple questions. I'm sure you agree. So the next point is lease termination. So you mentioned this with the California AB. Oh gosh, I forgot it
1482.
already.
1482.
So is it possible to give a 60-day notice in California on a month-to-month agreement right now? Basically, this person, her name is Jane, she needs a place to house her family who unfortunately has lost their jobs, and she wants to give her tenant a 60-day notice. Is that possible at this point?
So again, it will depend on exactly where that person is, but let's just say it's just a statewide issue. The notice would have to comply with that state eviction control, AB 1482, and there are exceptions for owner occupancy, or just I no longer wish to rent the home or the unit. Now, if it's a single family home, of course, it could be exempt altogether, and you could give that sort of a notice. I'm not seeing any restrictions in place right now at the state level that preclude you from giving a termination notice. Now, again, that may be restricted locally. There may be something that restricts it locally. Now, if the notice were to expire during the emergency period, of course, you wouldn't be able to get anything done in court if the courts are still shut down. But I'm not aware of anything that specifically says you can't give a notice right now, so long as you do so, in accordance with whatever just cause is in place. Now, there is an order that's extended through May 31st for the state of California that says you can't terminate a tenancy and then charge someone more. So if you want to put a new tenant in, for instance, immediately after, you can't do that and then charge that tenant more than what you could have lawfully charged the tenant you just evicted. But that doesn't seem to be the case with this particular question.
I'm glad you addressed that about charging more, because there was another question about charging if you reduce somebody's rent during this time and then the pandemic is over, can you then bring it up to the market rate? Would that be considered a rent increase if you reduced the rent?
Okay, now again, I don't know if this is California specific, but just in general, I would not treat any concessions as a rent reduction. I would recommend against that, because then you trigger potential rent control laws if they're applicable where you live, which then, well, can I then get it back up? And that's going to be a case-by-case basis depending on where you are. I would instead, look, the rent is $2,000 a month. You're paying $1,000. You still owe that additional $1,000. We're going to defer that until after the emergency orders are lifted and in accordance with any guidelines that are in place for that particular jurisdiction. So it's just a deferment. You're not reducing the rent. I would not recommend that.
And get that in writing.
Yes, that was the other question, is how much of this do I need to get in writing? And
Everything.
I think it's everything. I mean, if you're even writing down how you're cleaning your doors, I mean, you should definitely be writing this stuff down and getting it from your tenant. So the other thing as well is if the rent is deferred, let's say you decide to do that, and then later they never pay you that amount that was deferred. That's a big fear that I've heard from a lot of landlords. Is there a way to collect on that? What do you think?
For the most part, that would be following up with usually a non-payment or rent eviction notice. So once any moratorium has lifted, then the rent's not forgiven forever, at least not yet. Like I said, there's a push in my area to make it forgiven forever. Hopefully that's not the case, but if not, then you can proceed with generally in California, it's a 3-day notice to pay rent or quit. Now, under some some of the moratorium laws, instead of a 3-day, you then have to give, this is San Francisco again I'm speaking about, you have to give an additional notice. Instead of that 3-day, it's got to be a 30-day notice. So there are some additional hoops you may have to jump through, but generally, once you've jumped through them, you can evict them for non-payment of rent. Doesn't mean you're going to get your money, but you may get your place back. So there is still some recourse to recover the rent that was deferred during that time, subject to any law changes that may come down that may forgive that rent altogether. Hopefully that's not the case.
Yeah, I think it's a point worth highlighting is to the extent that you can recover, right? Because it's, we as landlords, we're worried about the income flow coming up to us from our tenants, but remember the landlords themselves are also obligated to somebody above them, which may be their mortgage holder. So just like they may not be able to collect against their tenants, the question is what about your creditors? Are they able to collect against you as well? So it's worth noting that there's two phases to any type of litigation transaction. There's the liability issue, and the liability is the breach of contract. Did you run the red light? Whatever that liability component is. But then don't forget that there's a second component to litigation, which is the collection phase. And what Steve has just talked about was the collection phase. You may have been able to legally get somebody out. Now the question is, are you able to collect on those past due rents? So that's a lot where asset protection comes in. But many times if the client or the rent or the tenants don't have anything, I mean, literally because they lost their job and don't have any money, well, you can't get water from stone. I mean, that's just the way that it goes. But if they do have something, now you have an entire collection component that goes on. And it's not that easy. It's not that you win litigation, the judge smacks down the gavel, and next thing you know, money is pouring into your bank account. There's a whole nother procedures involved in collection. So that's why, again, from my point of view, as an asset protection lawyer, we want those structures and those ramparts and those barriers in place to collection beforehand, because it's the collection phase is where the asset protection has its most effectiveness. Not so much on the liability phase. You did it, whatever the case may be, an accident that happens. Now the question is, to what extent are you able, or is the creditor able to collect on that? So that goes across the board.
That's a good point. Just to follow up, Alexander, so I mentioned you could, bring your 3-day notice and potentially evict the tenant or recover possession. And part of that may include a judgment from the court for possession of the home, which is great. You get that, but you want the rent too. And oftentimes that judgment would include the rent that's due. I almost across the board tell my clients, look, once we're going down this path, we'll get you possession, and that's a win. Actually collecting the money that's due, even if you have a judgment against the tenant, is oftentimes icing on the cake. It's oftentimes going to be too costly to try and collect that, then it's even worth. So sort of back to your question, that you may never get the actual money, but your recourse is to at least avail yourself of the right to get a judgment for that money and for possession of the home.
That's a win. That's right.
Just a moment. I'm going to plug in my laptop. I am running out of battery. I just have a few more questions left. Just a second.
Sure.
Oh, and maybe I'll leave you with a question before I go.
Okay.
So the next question is, what about tenants who are still getting paid but refuse to pay rent?
Yeah. So what I've seen in most of these orders that are placing a moratorium on non-payment or rent cases, most of them require the tenant to provide proof that they're unable to pay due to the coronavirus. And for instance, some require you provide documentation showing that you've been laid off or your income has been reduced or something to that effect. So, in theory, if they're unable to do that, then any moratorium on an eviction for non-payment of rent doesn't apply. So at least a lot of these isn't just a reprieve from the obligation to pay rent and letting tenants who can't afford to pay not pay, but instead they generally require some form of proof of inability to pay.
Oh,
Oop.
you're on mute.
Yeah, you want to take it off mute, Alexandra?
Sorry.
Yeah,
I'm sure that was a great answer. Didn't get to hear it, but
Best one I've ever given.
okay. Dang, I missed it. I'll have to listen to it later. So the other question that I was getting quite a bit was people who had evictions that were started before this, and now everything's been put on hold. Like, what do you do, right? So, for example, I had someone here, Eric, saying that they literally were going to have the sheriff do the lockout, and the day before they issued a request to put it on hold, and they're not going to do lockouts anymore. The day before, the sheriff was going to go. So how do we get the sheriff to enforce the judgment? Can we file for collections on the judgment before the eviction by the sheriff?
Yeah, so in general, so pending cases, those are just all on hold. At least in California, all litigation is just being pushed out. So that gets to the question, well, all the litigation is done. All they need is the sheriff to enforce the judgment, which the sheriff is supposed to do. For instance, in Alameda County, the sheriff there has put a moratorium on all evictions at this point. So any enforcement of a judgment is on hold right now, in at least, in Alameda County, and I'm assuming other counties have similar, similar stays in place by the sheriff there. But my experience with the sheriff is the sheriff's going to do what the sheriff's going to do. Even if there's a court order saying they've got to do something, if for some reason they're not, you can't twist their arm to do it. You got to go back to court and have the court make them do it. Which I have done in the past. Even that's a lengthy process. But remember, the courts are shut down. So right now, there's probably not going to be much movement from a sheriff in that circumstance. It's going to be on hold until such time as any orders are lifted.
Okay, and just two more questions to finish. So one is, there's that $1,200 check coming to some people. Does that need to be used towards rent? Is there some sort of requirement for it to be used towards rent? What do you know about that?
Steve, I'll let you go. I don't have an answer for this one.
Sure. Yeah, I'm not aware of any, that for that to be earmarked for rent.
Yeah,
No,
that's my understanding.
I figured.
Yeah,
Unfortunately.
I would not, and I have had clients ask that. Well, can I tell them that they need to use that toward rent? And I say no.
I think most people are going to use it for probably food and other necessaries. I mean, certainly shelter is as well, but I think a family is probably more concerned about putting food on their table than they are about paying their landlord in their own priorities.
Yeah, obviously that's going to take priority. And then last question, I put it in the other category. I had two people ask me about vacation rentals. Does any of this apply to vacation rentals? Are they kind of the same thing, or are they different in any way?
Well, I'll just pop in real quick. There really isn't any difference from our point of view as far as a source of liability. As a matter of fact, we find vacation rentals are a little bit of a higher risk profile, just because of the types of activities on there. You have a much more transient type of tenant. They're there for a weekend. They're there for a week at a time. Typically, they're a little bit more in the party mode. Maybe there's a lot more people kind of coming and going. And so they're a little bit more of a higher risk profile. But the tools that we use, whether it's a vacation rental or it's a long-term, year-long or reoccurring leases, the tools that we use are the same. It's just that this may happen to be a little bit more of a higher profile from a risk portfolio than maybe a traditional, single-family home that's got a long-term lease tenant in there.
Okay, so with that being said, I think we've covered most of the questions. There were a few that I didn't get to, but I'll be sending those to you all directly. But I think we covered what's been on most people's minds. I tried to hit at least the ones that I got more than one of. And I'm really glad that you all came on again, because it's something that I think people need. We need answers, and it's awesome to have a team like yours, Brad and Steve, that can address both the asset protection and also the eviction and landlord tenant law. So again, thank you so much for coming back, and hopefully we'll make it through this.
Okay.
Okay.
Okay, thank you.
All right, guys. Take care.
Bye.
Bye.